What the judge said next left the entire courtroom in silence. The court just shattered a major myth: a child cannot be used as a pawn to prove adultery. The court set aside the trial court's order directing a DNA test of the minor child. The right to identity of a child cannot be sacrificed for the purpose of proving one party's case in a matrimonial dispute. The court recognized the relevance of DNA testing in determining paternity, but only when necessary and proper. A minor child's right to identity cannot be sacrificed for the purpose of proving one party's case in a matrimonial dispute. Justice Renukayara. In a significant ruling, the Telangana High Court has set aside an order directing a DNA test of a minor girl child in the course of a matrimonial dispute. The court held that the right to identity of a child cannot be sacrificed for the purpose of proving one party's case in a matrimonial dispute. The background of the case is that the husband filed an application seeking dissolution of his marriage on the grounds of adultery and cruelty. He alleged that the wife was having an extramarital relationship with a third person, was quarrelsome, and had never shown interest in living with him. The central allegation was that the wife declared the minor child was not the daughter of the husband but was the daughter of the third person. The husband filed an application under Section 45 of the Indian Evidence Act seeking direction for DNA testing to determine the paternity of the child. The trial court allowed the application and directed both the husband and the minor child to appear before the Director, Forensic Science Laboratory, for a DNA test. Before the High Court, the revision petitioner contended that the husband had the capacity to manage the DNA laboratory and obtain a report in his favor. It was further alleged that the husband had already collected DNA samples privately, obtained a report in his favor, and on the basis of that private report, had evicted the wife and the minor child from his house. The High Court noted that the Indian Evidence Act was enacted during the British era when the science of DNA testing was not available. It observed that with the subsequent development of DNA testing, courts have in appropriate cases recognized its relevance in determining paternity.
Here's what this means for you. If you're facing a similar situation, consult a lawyer and file a revision petition before the High Court to protect your rights. Save this video for future reference.
Follow Legal Output on Instagram and Legal Output Official on YouTube for daily legal updates.